back on the record, counsel and parties are present, our jury is not present.
Well, the problem is it does deal with the subject matter of the last unrecorded sidebar, and I'm not sure if the court wants third parties present in recording this.
I think it's okay.
Okay. The people are requesting to reschedule that issue on Thursday due to the excessive length of cross-examination has caused delay, and the court had asked for some
testimony to be elicited from certain witnesses about the location of certain items.
Prior to that happening, sorry, I was at a loss for words. Thank you, Ms. Rodriguez. And due to the delays that have been caused by that excessive cross-examination, we do not believe...
Characterization at this time, if the defense wants to cross-examine a witness, it is not the people's place to say it's excessive.
I understand.
Due to that, it has caused some scheduling constraints to be able to accomplish what the court asked. We can give you a benchmark witness that would be relevant for that, for the court to then reschedule what it had intended.
That's fine. We can. There's no magic to the date.
Okay. The second issue is that it appears that we're going to have to relitigate some of the things we have already litigated in the 1101 issue. And we have concerns because one of those witnesses, based on the court's ruling we relied on, are flying in for a particular date.
There's
two witnesses.
Particular witnesses from Geist Construction that were part of the 1101 motion that the court ruled would be admissible. And in addition, we had a witness here yesterday, Ms. Fonseca, that has to come back again another time. But yes, we are flying two witnesses here. I don't want them to get in and then find out that they're not going to be able to testify when the court's already ruled that it's admissible. So
or there would be a substantial delay in their testimony due to having to relitigate those issues. We'd like to address them in advance so we do not further inconvenience Ms. Fonseca or cause undue delay or expense to the people from Geist Construction.
I would not be inclined to relitigate issues that have already been litigated in the unlimited motions.
Just so the defense is clear, all the offers of proof of what they said they were going to bring Mr. Cicada for, the court excluded, and then they litigated, and now the court allowed them to bring it in. So anytime there's any new litigation, it's because the people are calling witnesses that the court excluded.
That is not true, sir.
I'm not done talking. And then also there's a Geist issue that the court said can come in. A concern from the defense is they might want to try and get in more information that they didn't alert the court. So if there is other needs for motions eliminated before a witness, that's because the people may be trying to present stuff either A, that the court's already excluded, or B, did not give advance notice to the court and to rule on. Well, if the court has ruled, we won't try and disturb those as long as they're actually followed by the people.
Your Honor, that characterization is completely inaccurate. The people were calling Mr. Cicada based in my notes specifically, do not go into these subject matters because you had already ruled to exclude them, and I was going into other things, specifically the business relationship between Mr. McStay and Mr. Merritt. Because of their 402 objection and request, then the other issues bubbled up in that argument. I personally was shocked and surprised that the court made its ruling on the one topic of issue because it was in contravention or a change from your 1101B ruling. However, I wasn't the one that brought it up. They did. My intention was to bring up only those things that I proffered to the court initially. I did not take that conversation down the road as to that misappropriated check. They did. So to accuse us of trying to relitigate things at the last minute is a completely dishonest characterization of this court, and the record reflects it.
Well, I agree that the areas that the court indicated that Mr. Cicada would not be able to testify about and were excluded in the unlimited motions were not the areas that counsel indicated he intended to go into with Mr. Cicada. He had other areas he wanted to go into. I understand the defense initial concern were the court excluded certain information or certain material that the people indicated they intended to offer from Mr. Cicada, and then they say, now we're calling Mr. Cicada, I can understand the defense concern, like, wait a minute, this has all been excluded, but Mr. Hines made it clear he was not going into those areas. He was going into other areas. We had an offer of proof here, and I allowed him to go into those areas if he could lay the foundation, which he did do during direct examination. So I don't see the necessity for re-litigating issues that have already been litigated.
But I do want to add, though, yesterday, the very same thing happened, Your Honor, when we went to call Elba Fonseca. All of a sudden, we needed to have another 402 hearing on what she was going to testify about.
And the reason for that was when we had discussed Ms. Fonseca's, in the limiting motions, when we had discussed her testimony about certain interactions between Mr. McStay and Mr. Merritt in business and financial transactions. I did not, at the point where it was being mentioned, I did not recall any specific date. It was my impression on the limiting motions that occurred in the 2009-2010 time frame. When we were at the bench yesterday, defense counsel said, wait a minute, this relates to 2007. I did not recall that from the limiting motions. I reviewed my notes of the limiting motions, and I did not have anything to indicate that it was from 2007. And the issue then, is it remote, or does it still have some probative value? The fact that it was from 2007 should have been made clear during the limiting motions. But at least according to my notes, it wasn't. So there was some new, at least as far as I was concerned, there was some new information that potentially could have affected the admissibility.
I will say that defense counsel was aware of the time frame because it is in the report. That
Well, I have no doubt that everyone was aware of the time frame. I don't think that was made, either it wasn't made clear to me in the limiting motions or I missed it.
Okay, because it was my understanding that the court reflected that if she had personal knowledge on those subjects during the time frame that the defendant worked with Mr. McStay, that the court was going to allow her to testify about those things.
True, and that was based on my assumption at the time of the limiting motions that occurred in the 2009-2010 time frame. The first I heard that it was 2007 was yesterday.
I think the problem is there was a misunderstanding about, or a presumption as to the length of time that Mr. Merritt and Mr. McStay had any type of working relationship that may have contributed that. That aside, because the defense seems to be big on notice, we are bringing the Geist people in to testify consistent with the court's rulings of the 1101B motion and Ms. Fonseca. We are asking for the courtesy and the court's indulgence for advance notice if we have to relitigate any other things to avoid undue expense, undue complication, undue delay in effectively presenting their testimony, because it presents a hardship on them.
Sure, I understand.
We're here for the long haul. Witnesses having to sit out in the hallway forever and then having to relitigate these issues or having to buy plane tickets, that's an undue burden on them.
I understand. I agree with that.
The reason we brought it to the court, all these other side issues are what they are, tangents. What we're simply asking for is courtesy for their sake to address these issues ahead of time rather than at the last minute, such as when we stand up to call them as a witness.
I can address that, a couple of things.
Sure.
One, we're giving no advance notice of who they're calling until the night before, 5 o'clock. We don't know who they're going to call after Carmen Garcia and Mr. Cicada. The people refuse to tell us. I asked them, when are you calling your cell phone expert? Because my expert who lives in Washington, we have to buy a ticket. We have to house him here so he can watch. They looked at me, smiled, and walked away. And the court's paying for these witnesses to fly, not the witness. And the people refusing to share a schedule of what witnesses they plan to call and when, so we can have the proper witnesses here or we can properly prepare. They complain about we have to bring up 402 issues last second. We bring them up at the first opportunity that the court's on the bench when we've informed they're calling that witness. So it's not the fault of the defense that we're doing stuff last second when they are purposely hiding their witnesses they're going to call, who they're going to call, when they're going to call it, so we can all coordinate together and do a harmonious trial before this.
Again, these accusations are completely unfounded.
I ask that the court remind people that do not interrupt while I'm speaking. They like to do that, and I'll just have to finish my.
I'd like the same courtesy.
Well,
Oh my gosh.
so let him finish.
So all the defense is asking is, give us notice of who you're going to call. If we think there's a legal issue, we can bring it up in a timely manner before they even come down to court, so we can not waste the witnesses' time as well. If that's a concern of theirs, we share that. Give us the opportunity to see who you're calling and what issues we have to address, and we'll address them in a timely manner as soon as you tell.
Well, you know who's on their witness list yet. So if there's an issue about a particular witness that you feel needs to be raised, you don't wait until they're about to call the witness and the jury is here ready and say, oh, now we need to have a 30 or 40 minute or longer discussion about the witness.
Well, that's a funny point to bring up, Your Honor, because we've never received a witness list from the people.
That's not true.
I'm not done talking. Again, another example. They gave us a list of 184 people. And they said, this is our witness list. And I said, you're calling 184 people. And they said, well, and then they highlighted names. It's like a proper witness list, according to 1054.1, is the witnesses you're going to call, the address to which they can be contacted, so the defense can contact them and prepare. And then also, if they're an expert, we get the CV and any reports that they have 30 days before trial. We received this, the one highlighted list, about 2 weeks ago. We get CVs. This week we didn't get it. CVs of these witnesses. So to say that they gave us a witness list is preposterous. We should have had it at the end of September so we can plan this out. They have not fulfilled their requirement. I gave them a case of People v. Lewis saying you have to give me this information in a timely manner. That case said it's not Brady violation, but they have to show good cause why they did not follow their requirements under 1054.1. And their position is, we have given you all the police reports, all the names and contacts information's in there. So they're saying contacts from 2010 in the San Diego report is a good address for their witness, and that's good enough. And that is not what Lewis says, and that is not what 1054.1 says. So for us to say we have our witness list, we don't. We've been asking for one over and over, and the same response we get is, you have reports, we gave you 100, we gave you the names in the jury list in the questionnaire, and they think that satisfies their requirements. So technically, we have not been given notice that we're entitled to under the law.
And you should have brought the appropriate written motion prior to opening statements.
And we've discussed that amongst the party, but we keep trying to just do it informally with the people to say, let's just solve this issue. So
well, and the court did indicate that both counsel, when you're presenting, whoever is presenting their evidence, should give notice of witnesses that are being intended to call at least a day or two in advance.
And I have done that, Your Honor. We have told them every night before we leave who we're calling the next day.
And the problem is that with the excessive cross-examination that is not necessarily anticipated by the people, the schedule, if we had one to give them, cannot be held to, because all of a sudden we have Detective DeGaulle on for a day and a half or 2 days, or Miss Williams has to come back the next day. So it pushes people down the line. We give them sufficient notice when we can fit them into the schedule. We told them today that we had Miss Garcia. We told them yesterday we had Miss Fonseca. We never got to them due to the excessive cross-examination that was not necessarily anticipated by the people, because we can't necessarily anticipate how long cross-examination is going to go. And so when those scheduled delays occur, I can give them a schedule. It's not going to be accurate because I can't foretell the delays that they've caused. And then we have to reschedule them to a date that's convenient for them.
Well, you can at least give a schedule of, these are the next 2 or 3 or 4 witnesses that we're intending to call. If it turns out the first witness takes 3 or 4 days, then we're not getting to them, and that may change the schedule. But you can at least give them the schedule of, these are the next, as I say, 2 or 3 or 4 witnesses that we're intending to call.
We have done that every day, Your Honor, and I might add that we have not received any of that information that defense has a reciprocal obligation to provide under 1054 as well.
Well, they're not calling witnesses right now.
Well,
And the one issue that we have, if we're told at 5 o'clock, these are the witnesses we're called tomorrow, that means that we're working with our staff till 9, 10, 11, 12, 1 o'clock in the morning, and not even get to consult with our client because we're busy trying to get together with what they're telling us last second. So the detriment to the defense to be prepared is clear and obvious. And then we have to come into court without sleep. I've told Mr. Moline, you need to get sleep on multiple occasions because we're working overtime and through the night to try and catch up to these surprises. So the difficulty from the defense side from these surprises is shocking.
No, I just say that I'll sleep through Mr. Hines' direct. That's what I just I tell him, no problem.
Well, you may not know the exact time a witness is being called, but you do have the discovery. I'm assuming that you are prepared with what you expect to be presented. It's not like, oh, I didn't know this witness was going to be called. I didn't know about these reports. So, this is my first notice of that. If that were the case, I would assume you would object to the witness being called because you haven't had time to prepare, and I would grant that.
Your Honor, we're going to comply with the court's order, which you told them to give us 2 names before, give us the names the day before. But I just have to say, on just a discovery and formal basis, it is very discourteous to give us the names at 5 o'clock because Mr. McGee's right. Both of us have to drive out to the jail at night. The jail only lets us stay till 10 o'clock, so if I have to go over things with him, they kick me out at 10 o'clock. It is so discourteous for them to proceed in this manner, but we've accepted it. We've accepted it, and we're trying to deal with it.
I agree that you should get more notice than 5 o'clock the night before as who's being called the next day. You need to have notice of witnesses who are coming up. As I said, the next 2 or 3, 4 witnesses.
And Your Honor, on many occasions, they have been given more than that notice. They were also given a witness list that highlighted the ones that at that time we intended to call, which was not 184, 189 people. So they have a field of people that they should know and be prepared to be called. And we do provide them sufficient notice or reasonable notice when we can schedule them based on the way the schedule keeps shifting due to the delays that have been there. We are doing our best, but like I said, we cannot anticipate 3 days of cross-examination for a single witness.
Well, you should when it's the primary investigator of the homicide scene in 2010.
there's been 3 witnesses.
I understand that there may be differences of opinion as to how long an appropriate examination is, but obviously each counsel is entitled to conduct the examination that they think is appropriate. So, if it takes longer than one side thought, so be it. That's part of trial. But I think there does need to be adequate notice of witnesses that are coming up more than 5 o'clock before the night before they're called.
Well, that's what they're doing. And that's what the court said.
3 witnesses this week, Raj.
It doesn't matter. That's what you're doing. And so we have to deal with that.
No, that is not what we're doing. There's only been 3 witnesses this week, and they were told of those witnesses on Friday. They knew exactly who we were calling. We haven't gotten through, actually, I think we told them 4, and we only got through 3 of them.
Well, yesterday they told us the witness that was on today, Mr. Cicada Jr. So that was yesterday.
That's not true. That is not true.
Yeah.
So here's the, fine, for the court's edification, we will try to have a full week next week with Mr. Bluth, Mr. Hart, Mr. Avila, Mr. Bachman, Ms. Radliff, and Mr. Steers, and Ms. Gray, and maybe even Dr. C. But I can guarantee you we'll probably get through 2 of those.
We're not going to apologize for our vigorous cross-examination as opposed to what he's characterizing.
I
And
have no quarrel with defense counsel or the people taking the time that they deem is appropriate in either direct examination or cross-examination of a particular witness. We can all have opinions as to whether or not it's excessive or inadequate, but other people's opinions don't matter. So.
And two things. One, the list, can we have it just by email so we can get the proper witnesses, just so we have notice and they can document when they told us for their own information? That'd be preferred to Mr. Molina and myself, so we can get our forwarded to our staff.
Sure.
I believe they'll have the record of the transcript.
Well, we don't get that transcript until tomorrow or Monday.
You can email them the witnesses that you're intending to call next week.
And second, can we approach regarding the rescheduled matter just for discussion of that off the record?
I don't believe it should be off the record.
Well, it's
I don't know
just,
when that's even going to happen at this point.
it's just a request to discuss some idea off the record. It's not a decision or pertinent, it's just a suggestion.
All right, we can discuss that later when we're at a point where we know we're going to have the foundational testimony for it. I think we have adequate time to schedule it. I'm not worried that we're suddenly going to say, oh, it's too late, we can't do it.
Right.
So, all right, we're in recess.
Thank you, Your Honor.